I'm doing my presentation a little bit differently than I have in the past. I've done the no fault stuff, ICL, brain injury, and I always do a PowerPoint, or I have so far. This particular topic is so dense that I've actually chosen to do it a little bit differently. So definitely let me know how you guys feel about it, whether you prefer everything a little bit more condensed and a little bit more entertaining. I don't have all of the time to make it as much fun as Professor Miller does with his decks, but I guess I might as well just jump right in. So a lot of you probably remember a company called Velocity that nobody really was aware of until about 2018 or 19. It's a medical factoring company that came to Michigan, and it had no idea really what Michigan PIP was about. It had funded other states, no problem with PIP, but our system was so much different. They actually lost a ton of money. And what ended up happening is they started funding, they started seeing all of their investments go south. So they started sending out lien letters. This was really the first time that PIP insurance companies ever even noticed that this was happening. And with Velocity, it was a legitimate concern. They would get faxes, letters from another entity saying, don't pay the patient, don't pay the provider, don't pay anybody. We own this, you have to pay us. Meanwhile, there's already a plaintiff in litigation demanding the same bill. That's a legitimate concern. That's not really what this issue has evolved into. At this point, it's only become a way to circumvent liability for otherwise compensable claims on a technicality. So a big part of my presentation today is how to avoid that from the beginning. It's also how to deal with it retrospectively when you can't change what already happened with the contracts and the transactions. Just keep in mind throughout the discussion that the only true interest that the PIP insurers have to defend is duplicative payment. And you're going to see a lot of arguments that have nothing to do with that. And in my brief, I'm going to try to explain how we bring all of that back to the forefront to get correct rulings. And I wanted to mention also, Wayne mentioned this morning that we often agree on the viability of certain legal arguments, which is absolutely true. I still cherish our conversations. I think it makes us both better. At least it helps me in formulating my own arguments. They always help me understand the issues. And actually, it's kind of funny too. I actually added a new facet to one argument that I'm going to talk about today because of something that Wayne said this morning about overdue bills. So with that, you can follow along with me on the outline here. I'm not really going to get into the brief until we get into the facts. And as always, if somebody can point out, I don't think I have the chat window open, but if anybody wants to ask a question, feel free to interrupt. So the first thing that we need to know is what medical factoring is. Stated very simply, it's a process where an investment company provides capital to a medical provider in exchange for an interest in a particular receivable, some patient account. So factoring the term as a term of art in the financial industry refers to a complete sale. That's part of the definition of what a factor company does, is that they fully purchase the account receivable. And a factor is the name of the company providing the capital, like Velocity, or you've probably seen Easy Med or MedSource or any of the others. So the interesting part here, even though these contracts, in my experience, are drafted as a complete sale, they're called factoring agreements. The companies are called factors, which implies that it's a transfer of all rights. And in fact, the plain language of the contracts indicate that it's a transfer of all rights. The business dealings almost universally contradict that. We'll get into that a little bit too, but before we do that, we got to talk about how the process works. So it's really very simple. Provider treats a patient, bills the insurance. That's what creates an account receivable. Provider and factor enter into an agreement whereby, and this is kind of an interesting part that a lot of people don't realize. It's not an instantaneous, I'll give you X and you give me Y, and it's an exchange. The original agreement is always, it gives the factor the option to purchase accounts receivable in the future. They don't specify any accounts, no names, no dates of service. It will potentially have an amount of money or a percentage in it, but it won't actually be applied to any services that have already been provided. So it's going to explain a lot of things. These are very dense. I wish I could actually show you one, but every single one that I possess right now is under protective order. Even that, I can't even give you the exhibits to my appeal. I'll give you my brief on appeal, but I can't give you the exhibits because it's all filed under seal. But a lot of these, just to explain briefly some of the terms that you'll see, the provider does have some good faith obligations. You can't offer for sale an account that has already been litigated and dismissed, something that's already been paid, or you know it's premised on fraud. Of course, they have those obligations to operate in good faith. There is a different scenario when an account ends up not payable or otherwise uncollectible through no fault of the provider. And these contracts are different as to what happens in those instances. So make sure you pay attention to what they say. There's also an issue. Some providers, or even their individual personal human being owners, will back the debt or essentially a loan. So if sometimes the factoring company will require a certain return or a certain amount of money. And if those accounts receivable that were transferred to meet that goal don't, they can actually come back after the provider, potentially even an owner, or as usually what I see, those files just get replaced. They keep replacing files until they meet that goal. Now, the most important thing to recognize, as we'll talk about later in the legal analysis, is what happens when you do collect on that account receivable and it's more than what the factoring company said it required in return. When it's a true sale, the factoring company keeps everything. But also when it's a true sale, you have to remember the provider would never be under any obligation to reimburse, to personally pay, or even provide a new file, because if it's a true sale and not a collateralized loan, then once that transaction is over, the funding company is the only entity that has any right. That's not what we see. Usually what happens is that amount is split between the two companies at some sort of ratio, often 50-50. So, funding company gives 25%, they require a 50% return on that. And if you end up making more than both of those put together, it would be split half and half between the factoring company and the provider. It's very tricky to determine whether these are sales or loans. And again, this is extremely important for the purposes of the legal analysis. A true sale requires a complete transfer, no remedy against the provider by the factor, other than obviously fraud and the things that we talked about before. The provider has to have good faith in selling these. But again, the provider would have no right. Where the provider guarantees a particular lump sum, even though the document, the contract will call it a sale and it will say in 4 or 5 different spots that it's a complete transfer, it will also say somewhere else that it's basically really a loan. It's not this particular account that satisfies the provider's obligation. The provider's obligation is not satisfied until the factor makes X number of dollars or a certain percent return. And that's the part to focus on because it creates ambiguity as to whether it's a sale or a loan. And just to be clear, which I haven't said already, again, I apologize, I'm a little behind. Just to be clear, we always want these to be structured as loans. It's always better for us if the court understands that this is a secured loan and not a sale or a complete transfer of the cause of action. Now, and I explained in here the reason why, just very briefly. The factoring companies use this as commercial paper. So under federal law, they have to have complete ownership of it so that they can go take out loans against that commercial paper. It really has nothing to do with us. And ultimately they are loans. And it's really not, I work very well with the factoring companies, but they have not had any issue with me arguing this. And I do communicate that with them. So ultimately, the contract is often contradictory. And we're going to talk also about, it's going to become important what the business operations between these companies are as well, regardless of what the contract says. So to determine whether sale or secured loan, we've got to talk about what exactly is transferred. At least the beneficial interest in the account receivable is transferred. There's no question. A lot of these they define account receivable. They say, you're giving me the right to this money that you would otherwise have a right to. That is just a transfer of the beneficial interest, any money that's collected. To be a true sale, you have to sell the entire chosen action, the cause of action, the entire thing. You can't retain any rights. Now, the reason why timing is key is because the usual course of business purportedly transferring whatever rights at the time the original contract is executed, that usually happens before the services are even provided. So some of you may already have bells and whistles going off about 3143, and that is my primary argument. But just keep in mind that the timing of when these documents are executed is absolutely key to our best argument to prevent dismissal of these cases. And to be clear, the original I've never once seen an original contract named parties, dates of service, any particulars. They'll have, like I said, the percentages and the other terms, but it doesn't have any specificity as far as particular accounts receivable. And that's important as well. Regardless of what rights are transferred, whether it's a beneficial interest only, just the money, or whether it's an actual sale of the chosen action and they get everything, these contracts often assign or identify the provider as what's called a servicer. A servicer of an account is the entity that has the right, or I actually argue the contractual obligation based on my contracts to pursue the collection. And this is again why the contracts are almost always contradictory. They'll tout themselves, and one space they'll say, this is a true sale, we're giving you everything, but then they're going to say, well, but provider, you still have obligations on the back end, not only to service these accounts and actually go collect for me, but to pay back anything that I don't, or that I had expected. I need to make all my profits. So you still have these obligations, and all of these things indicate that it's not an actual sale. It's truly a loan. So the easiest way to talk about this is a particular set of facts. And the reason I use this particular brief is because it's my very first one that I've done in the Court of Appeals. This is going to be up for oral argument within the next 6 or 8 weeks. I just got the letter last month that they're about to set it. It's a little bit irrelevant in certain aspects, but I kind of wanted to just run through it briefly anyway. You'll see in here, there's a lot of, in the actual brief, I talk about the names of the entities, the locations, and the contracts. I don't like people making poor arguments, ones that are a little bit tenuous at best, or even worse than that, disingenuous. But at this point, when an insurance company is relying on the language of these contracts to win a case on a procedural technicality, I have no problem using the same procedural technicalities against them. So that's what's in here. But what you really need to know for the purposes of today is that this is generally what happens, and this is what happened in this case. So my client enters into an agreement giving the factor the right to purchase future accounts receivable for a period of time. Provider subsequently treats patients, or in this case, one patient, on various dates of service for about a year, 14 months, creating charges for each date of service. It could be a $500-600 office visit. It could be a $90,000 ACDF. It doesn't matter. One CPT code, one date of service, one allowable, or one account receivable. Subsequently, once the treatment is provided, the provider and the factor create exhibits to the original agreement. These are the documents that actually identify the particular accounts: name, date of birth, date of loss, date of service, and obviously the balance as well. They'll just run through all the patients, and it'll be 30 entries for a patient because in the 2 weeks they had 30 CPT codes. It could actually only be 2 or 3 dates of service, but if there are 5, 6 CPT codes for each one, each individual one will be listed. Ultimately, at the end, there's a total amount of the accounts receivable that are being transferred, and then the factoring company accepts that exhibit and basically just cuts a check for the amount of the percentage that they had agreed to in the original agreement. There's no new paperwork, no more documentation, there's no new signature. There was a contract before the services were provided. Then they create these exhibits and the funding company pays. In this particular case, the contracts evidence that a true sale, at least as far as the money is concerned, not account servicing. The factor pays X% to provider, factor keeps anything. This one is an actual true sale, more so than the other ones I've seen. I was just kind of trying to make that clear in point 5 here. Another couple of facts that are very significant to remember: in all the years of this happening, well before velocity was known, well before this was an actual issue, no insurance companies ever actually had to double pay. The factoring companies, as a matter of course, don't pursue the bills. So as a practicality, The insurance companies are never going to have to double pay. In this particular case, and this is why I love that this is my first one that I have on appeal, the provider and the factor executed affidavits. The principals of each company said, my understanding of the agreement that we had was that provider was the real party in interest. Provider not only had the right, but the obligation to pursue collection. And that's both companies saying that, and that becomes extremely important as well. So now we're going to get into the actual legal analysis. The 2.116C5 is a throwaway. I'm not going to really get into it here. It's a capacity to sue issue. I don't know why defense attorneys incessantly cite to this rule. It has nothing to do with anything. The provider obviously has the legal capacity to sue as long as it's a Michigan company or has a certificate of authority and is a foreign company. What really matters, C5 has to do with standing, not capacity. This is really a C7 motion. You don't own this claim. Assignment prior to commencement of the action is one of the express provisions of 2.116C7. The main argument against all of these, and I think I've been driving this point home for 20 minutes now, is that it's all based on the timing. And I love using 3143 now, especially that we have the providers have their own direct statutory cause of action, and that a lot of our claims evaporated based on covenant. And it's pretty fun to be able to use this particular statute against the insurance company. So as we all know, an agreement for an assignment of a right to benefits payable in the future is void. You can't assign benefits that aren't payable yet. And what I'm saying here is if the original contract was executed prior to services even being provided, there's no way it could possibly validly transfer the right to PIP benefits that don't become due until the future. So even if, and this is the point that I was talking about with Wayne, this third bullet here, notice that 3143 doesn't say anything about when the charge was incurred or when the claim accrues. I mean, we know under 3110 sub 4 that a claim accrues at the time the charge is incurred. So you can sue once the claim is incurred, or at least I'm not going to step on Wayne's toes about 3112 and the provider direct cause of action. He did a great job on that. I'm not channeling, I agree with everything that he said, but at least we're talking even in the patient context, at least you can sue immediately after you incur the charge. So because 3143 doesn't talk about when the claim accrued, it doesn't talk about when the charge was incurred, it says when it becomes payable. So to me, that means you can actually make an argument that this is an assignment of a future benefit as long as fewer than 30 days have elapsed since the bills were provided to the insurance company. Not just before the services were provided, but 3143 says it's void if it's a right to benefits payable in the future, and it doesn't become payable until reasonable proof is provided, and then the insurance company has 30 days or 90 days if you don't submit it for 90 days. If you don't submit the bill for 90 days, they get that 90 as well. But so my conclusion based on 3143, and this is by far and away my strongest argument, at least on these facts, common to every single case that I've had with it, the provider remains the sole real party in interest. There never was a transfer at all. It's void. Even though they tried, it's wrong. It violates law, just like when providers try to do the same thing. When a patient comes in on day one and you get an assignment for treatment for a year, doesn't matter when you do it, but I'm going to assign that to you too. Anything that you do for me in the future, I'm assigning to you. You can't do it on day one. We know that to a certainty. This has been litigated to death. So because it's a future assignment, it's void. Now, the second argument is, I would say, just as good, and it's actually more important because it doesn't matter what the timing is. This is absolutely, in my opinion, the correct analysis of the law. And what you'll find, and what I found very curious about most of these motions that I see, is that rarely, I'd say 1 out of 10, maybe a dozen, the defense attorney actually cites the statutory definition of real party in interest. And I don't know if that's indolence. I don't know if that's ignorance. But to me, I think most of them do it on purpose because the statute is so plainly in our favor. I'm going to go down here to, let's see. I apologize. I haven't been scrolling through this. Another thing, a kink I need to work out, I suppose, doing this type of presentation versus PowerPoint. But the first thing, and there's a section in here you don't really need to worry about. Again, this is just developing the facts about, in my case, the insurance company hadn't even proven that my client had factored anything because all the documents were in a different name. Then there's the 3143. So here's 62041, which is the real party and interest statute. And the part that's bolded and underlined, the part that's important here is basically a party in whose name a contract has been made for the benefit of another. So where my client provider has entered into a contract for the benefit of the factor, the provider can sue in his own name without joinder. That's what the statute says. You can assign away your rights and still sue in your own name. That's literally what the black letter law says. So the next step is the joinder rule, 2.202b. So if there's a transfer of interest, and this is also, it's on 2 different pages here, but you can kind of read along with the exact text here. If there's a transfer of interest, the transferor can continue the action in his own name. In worst case, the court rule goes on to say, or you just join them. If there's an issue, just bring them into the case and we'll get it solved that way. You got to be a little bit careful, and I don't stress this court rule too much because there is a legitimate argument. And in fact, if I had to be completely objective, I would say that I believe that the point of 2.202b was where there's a transfer of interest after the action was commenced. And the reason I say that is because of how it specifically says can continue the action in his own name. And so there's a good literal, textualist argument to be made there. But essentially, I use this mostly to point out, look, we've got the statute, we know who has what rights, and then we've got the court rule to deal with it that says if there's an issue, joinder, that's it. So there's a little bit of case law. The George Poy case, I like going back to 1929 just as a way to start. And I do this on purpose, as you see in my brief. I mean, this law in Michigan goes back 100 years. The purpose of the rule is to prevent multiplicity of litigation. It doesn't even talk about duplicity of payment. It continues to say, as long as a defendant's rights are fully protected, literally, quote, he cannot complain. There's nothing to say. There's no defense. There's no interest to protect as long as there is the real party in interest. So how can we protect those rights? And these are bullet points for you. This is not necessarily what the case says, but basically we know what the point is to protect the defendant, and then he has no argument. So we can do a couple of things. We can do a new contract between the provider and the factor that explains the business relationship, how it always has been, how it continues to be. You can just do a release. I've had plenty of these settled. It's only a few insurance companies that are really going for the throat and trying to get cases dismissed. Most of them just talk to them and say, look, I'll get you released from both. That's why it's important to work well with these factoring companies and make contacts there as well, so that you can talk to everybody involved and say, hey, I'm getting this amount for this. You both tell me whether that's enough, and then you both sign away your rights and we'll get this done. Ultimately, which I have not actually had happen yet, joinder is technically what's appropriate. And I would be surprised if the Court of Appeals doesn't at least vacate and remand in my cases to discuss joinder. A little bit more recently, the right way refuse disposal. It's a 1987 case. Now, this one's not quite as good for us. The purpose of the real party and interest rule is concerned with the power of the plaintiff to bring the claim. And that's what most judges, at least in Macomb County and elsewhere, are really focusing on. Can this entity actually do it? But this case is good for us because what it indicates is as long as the plaintiff does have the right, joinder is not even necessary where other parties have an interest. It's not necessarily that particular instruction that's super significant. What's extremely significant is that you can have two. You can have the plaintiff in the case that has the right to bring that action while somebody else still has a right in the ultimate result. So that's the important part from the right way case, is that you can have two real parties in interest. But also this case is great because it does discuss the fact that joinder, it literally says right in here, it's not a question of real party and interest, but of necessary joinder. If multiple parties have an interest, it's joinder. The only case I've really seen to refute these arguments is Cannon Township, which doesn't really do much. The opinion does state that the assignor becomes a real party in interest, but it doesn't indicate that it's the only real party in interest. So it's distinguishable on that issue. I wish that it had been written a little bit better. You'll see in my notes here in my outline, I do concede there are, I can't remember what the count is, but there's 3 or 4 spots total where they're talking about a real party in interest. And sometimes they use an indefinite article a, sometimes they use a definite article the. So unfortunately, it's still confusing. Some defense attorneys will say when they say the real party in interest, it means there is only one. I don't believe that's what the Court of Appeals intended, and I know that they didn't do it in every instance, so you can point that out as well. But the conclusion that I draw from the real party in interest analysis here through the statute, the court rules, and interpreting case law, even if there was a valid transfer that was not invalidated by 3143, both entities remain real parties in interest. That potentially causes an issue for possible duplicative payment. But to the extent that there is that issue, the analysis says you do joinder. It's not dismissal. So some of these contracts, in fact, most of them, support another argument that these are not actually full sale factor assignments, transfers of everything. It really is just a transfer of a beneficial interest. And ironically, Cannon Township is the best law that we have on that. It specifically says in that opinion, which is cited at page 11 of my brief here, you can bifurcate the right to sue with the right to damages obtained in litigation. So the provider can transfer its right to recovery of the account receivable to the factor and still pursue the litigation. In fact, if it transfers only the beneficial interest, it is the only real party in interest. You have to own the cause of action to be a real party in interest. So there's a decent analysis. I should probably work on it a little bit more, but essentially I walk through in my brief, I define what an account receivable is. And it's all it is a balance due from a debtor on a current account. So with that simple definition, really all it is money from a particular source. If you get money from this particular source, it's mine. And to me, that's a beneficial interest. You're not transferring anything other than the right to whatever they collect. You go collect it, and whatever you get, give to me. A transfer of a beneficial interest under Cannon Township and other Michigan law is not the transfer of the chosen action and does not make the factoring company a real party in interest. I guess this might be actually, so it's not maybe the best argument, but it's my favorite one, just because of the creativity behind it. When the factoring company and the provider enter into their agreement originally, learn the process, get these affidavits that I got. What's interesting here, as we all know, I guess, I don't know if you remember all the way back at, contracts 1, to have a valid contract, there has to be a meeting of the minds, mutuality of agreement. Both parties have to understand their obligations and their rights. Otherwise, there is no contract. It doesn't matter what they signed. It doesn't matter what the plain language is. If they didn't have, if their minds were not made up in the same way about this transaction, then there is no transaction. The Hagerman case is fun. I'm sure most of us have used that in the context of challenging covenant type assignments to the provider by the patient. But what's interesting about this is insurers can't even argue what the factoring agreement says. It doesn't matter what they say. Oh, this plain language to me means X. It doesn't matter. They're not even allowed to discuss it. So ultimately, it's a catch-22 for them. Either the provider is the real party in interest per the terms of the contract and the meeting of the minds. You have affidavits saying, this was my understanding of what this contract was, is that provider was the real party in interest, had the obligation and the right to pursue the charges through litigation, or they were mistaken and that wasn't what the document said. And in that case, there never was a transfer at all. So either way, the provider maintains standing. Either there was a valid transfer and it maintained standing based on what the parties to the agreement understood, or there was never any understanding, meaning there was never any contract, there was never any transfer, and the provider still remains the only real party in interest. I know that was quite a bit. I do have all of that. I kind of want to distill down and just spend the last few minutes here talking about how to deal with this. It's definitely an unfortunate reality. I guess it's not that unfortunate. It is a reality of the US medical system. You got to have $5-10 million to start a practice at this point, just to start paying out before you get enough revenue to cover even your costs. Most of my clients, I've got pain management clients that have 500,000 to $1 million in costs and out-of-pocket expenses per month. So you can't just sit around and wait 2 years for insurance companies to delay, deny, defend, trickle in some payments here and there, and then go ahead and sue and start getting payments 2-3 years down the road. They can't do it. They have to have capital up front, and that's necessary for them to operate. So when this happens, just make sure you know about it. Let your clients know and get in on the process. I do this for free. I don't bill hourly. It's always better for my clients if I'm part of the process because I can review the contract. I guess one little anecdotal story, be a little bit careful. I did do this, and actually it was with Velocity 4 or 5 years ago for a client. I reviewed the contract. It was not a sale, it was a loan. Everything looked great. I never had any issues with his files ever, not once. Even once Velocity started sending the lien letters, I still never had any problems, not a single case dismissed on this issue for this client, partly because I helped draft the document. I helped draft the contract. Unfortunately for him, he had a problem in that he negotiated a factoring percentage that was so exorbitantly high. He wanted a bunch of money up front that I had to decide to settle his cases for like 95% to cover what he owed the funding company on the back end. So be a little bit careful about even the amounts involved. I kind of stayed out of that. And this is a cautionary tale because now that I know what the result is, I would absolutely advise my client on that as well. He knows that it was his mistake. I feel badly for not helping him with that though as well. So get in early, make sure that you can put in the language, put right in there that we're transferring the beneficial interest, put right in there that the provider is maintaining the cause of action. Do this up until the factoring company pushes back, and then you have to work it out from there. Even if you're late to the game, you still have to get in with these people, find the contacts. They need their money. In my experience, they're all extremely helpful. So they're going to get subpoenas regardless. People are going to find out. They're going to get valid, well, arguably valid. You can't really serve a Michigan subpoena outside of Michigan. But what I can tell you is they are responding to those subpoenas, whether they're supposed to or not. And this actually crushed me. I'm going to tell you another story in a couple of minutes. But even if you're late to the game, get in with them. Help them with the subpoenas. Help them produce the documents. What I do is I have the factoring companies just dump everything. It's really easy for them. You give them a patient name, whatever case you have for that provider. They run the name and it'll ping every exhibit to the contracts that patient was involved in. And then they also can identify what exhibit or which contract that exhibit pertains. So they'll give you, it's usually 6 or 8 different contracts that I get. And then obviously the same number of exhibit lists, but the exhibit lists obviously have the one patient that we care about, half a dozen times scattered throughout, but it's got hundreds of other entries in there as well. So you got to redact all of the other patients, and I always redact the percentages and the total amounts as well. Keep in mind that you have to redact the other patient stuff, HIPAA, you don't want to violate any of that stuff. I always also redact the numbers and the percentages, and I have not been forced to produce those. And that's kind of makes my 4th point here. This issue was initially legitimate about duplicative payment, but it's not anymore. So right now the primary goal is just to get everything dismissed. If they can't get it dismissed, the worst case for them, especially outside counsel, just gets to bill for it. Inside counsel looks like they're a real go-getter. But ultimately, worst case scenario, they could at least end up with, depending on some judge rulings, that percentage that the factoring company is paying the provider to purchase that receivable. And that's significant because I already know the end game here is that they're going to go ahead and try to use that as a definition of what constitutes a reasonable amount. So if the provider sells a $600 for whatever $1,000 bill for $200, the insurance company is going to say that's it. That's what the service was worth, and they've already gotten paid that, and they're not entitled to anything else. So I believe all of this is kind of a roundabout way to kind of just beat back the providers to a certain degree without any real basis. So this goes back to my third point. I had this appeal. So I guess to be clear, when I'm talking about this brief being my first appeal, is my first appeal in the Court of Appeals on this issue. I was hired to do one for an MRI company out of the original trial, or trial court was 31st Hamtramck, and Judge Crott there dismissed on this issue. I was not part of the briefing or anything there. I believe I did help out. I think I sent some materials to the handling attorney, but it wasn't me. Crott dismissed the case. They hired me to file the claim of appeal to the Wayne County Circuit Court, which I did. The great part about this case, and actually I'm still working it out. I'm probably going to be appealing this one to the Court of Appeals as well. The absolutely wonderful part about this case is that it's a single time transaction. It's MRIs, 2 or 3 MRIs on one date of service. It could not be clearer. In my case, you've got all these company names, all these different dates of service. There are all these issues about which contract, which exhibit, what. In this MRI case, it's very simply the contract was signed before the services were performed, period. The only document that exists in the record evidence that transfers any right is dated 2 weeks before the services at issue were provided. There's no other document after that. So the unfortunate part about this, or that I wasn't handling this, or that the factoring company wasn't as involved, is Judge McCarthy ruled the response to the subpoena to the factor had an affidavit that said, here's the stuff pertaining to this person. This patient's account was part of this contract. It says something almost exact, just, yes, this patient's account was part of this contract. Judge McCarthy ultimately ruled that the lay records custodian's affidavit controlled the law. And she said, well, the factoring company said it's part of it, so then it is part of it. I said, well, but what about the law? I actually did a pretty sassy motion for reconsideration. It was really just 2 paragraphs, one kind of explaining what she did, and then one gave an analogy. And the analogy is quite simply, okay, let's think about this in a different light. Patient goes to provider and signs day 1. Says, I'll assign to you all my benefits that come up in the future. Provider provides treatment for a year, ultimately goes and sues. Insurance company says, wait a minute, obviously before 3112 was amended, back when we were still dealing with, you had to have an assignment to have a cause of action. Insurer comes in and says, well, wait a minute, this is a future assignment, it's invalid. According to Judge McCarthy, the provider could execute an affidavit saying, it's my understanding as the records custodian of this facility that all of these charges were part of this contract. And according to Judge McCarthy, that wins. So the provider can unilaterally change the law by saying what it supposes happened in the past. So obviously that's not true. And obviously I'm still a little bit annoyed, to say the least, about it. But ultimately, we're going to have some sort of law on this very quickly. I haven't consolidated them yet, but each time I file a new appeal from the Macomb Circuit, I identify the first 2 cases. It's 358, 171, and then I also have 170 are both my appeals. And I've got 6, 8, 10 more since then. And I'm trying to get them all put into the same category and all decided at the same time, not only because I want the Court of Appeals to know how pervasive this issue is, but more importantly, because I think the more facts that we can throw out there and the more that we can show all at once that this is the business, this is how business is done, the contract is executed before the services are even provided, and there never is any documentation after that, I think that's going to help us create a blanket or get to a blanket opinion that we don't care about factoring companies. We don't care whether you had this agreement. It doesn't matter for the purposes of the No Fault Act. The provider is at least still a real party in interest. It's probably the only real party in interest because those transactions weren't valid in the first place. But even if we're wrong, and even if these facts don't apply to every single case, just tell the trial courts that joinder is the only thing necessary to fully protect the insurance company's interest. And that's the whole point of the real party and interest rule, is to avoid duplicative payment. And you can do that through joinder only. One point that just came to mind, I'm pretty sure it's in my brief somewhere, and some other people, it's not an argument that I make a ton, but oftentimes once the insurance company actually identifies this issue, files their SD or gets their documents or whatever, it's been more than a year since the factoring company has been assigned, whether it's been assigned anything. So a lot of my motion responses explain all of these things. 3143, it was invalid in the first place. Even if it weren't invalid in the first place, they're both real parties in interest and it would be joinder. But ultimately, joinder is unnecessary because joinder is only required where some other entity has a right. And once that year expires, the factor no longer has any right. So you don't even need to bring them in. And I like to do that at least in the trial courts because they don't want to bring in a bunch more parties. They don't want to substitute. And another practical matter is the factoring company. Okay, fine. Let's say the factoring company is the only real party in interest. What kind of discovery do you think you're going to get from the factoring company about that ACDF surgery? Who are you going to start? The whole thing is just kind of unreasonable. And I think the more you talk about the impracticality of doing this, it's the same way when I did my balance billing Court of Appeals argument. It's, look, we all know that it's a reasonable rate that controls. Tell me what I have to do. Either I as a provider can go get it myself, or you're going to make me sue the patient. We're going to do all these shenanigans and bring in the insurance company, and then we'll go to a jury on it. I'm going to get it. Just tell me what I have to do. And that's the same way that I'm going to explain this. We're going to get paid. Tell me which company it is. And I'm going to tell you why it shouldn't be the factoring company and why it should be the provider, and give them all the reasons why they should rule this way in addition to the black letter law. I think that's pretty close to my time, and that's all I had to say. Maybe I have a couple of minutes for questions if anybody has any.
Matt, are you pushing back in discovery when they're asking for these contracts?
Not really anymore. So I never really had this issue. I didn't really get started with it until Jen Measle left Haas and Goldstein. They hired me to do some of the appeals that in her cases that were dismissed. And then once she left, they gave me all of their trial court cases for C-spine. So I haven't done a lot of the discovery. I do absolutely push back. For example, I did have one where I substituted in AAA, Rob Heston, filed a motion to reopen discovery for this purpose. So of course I argue that it's futile. I kind of give all the substance of it, but the problem is the judges don't know the issue well enough to understand. And it's broad discovery. One thing that I have not done, and I'll leave this to other people, whether they think it's appropriate or not, is I have not made the argument that they're not a party to the case. So you can't compel me to do it. So I do that because I want to be part of the process. I don't want another McCarthy issue. And again, that wasn't even my case, but I want to be involved as much as I can because that protects everybody. I don't mind a little bit of extra work. I don't mind being the one getting the documents from the factoring companies, but there is an absolute, and you can take it as far as, go ahead, serve them with a subpoena, but it's an Arizona company. So you literally have to go to circuit court in Arizona and get a subpoena from that state. But again, the problem is they'll still reply even if it's a Michigan subpoena anyway. So the short version is no, I haven't really done that, but there are possible avenues to do it.
Okay, that's fair. I think Martin, do you have a question?
Yeah, man, I just was commenting on the 3143 argument that you made with regards to assignments made in the future because the claim is not technically payable until after 30 days. That concerns me in terms of all the assignments that we deal with are made right after the day of treatment, not 30 days after the day of treatment.
So that's a great point. And here's the answer is you may not want to make the argument at all because of that, but there is a response that defeats that argument. When a patient signs an assignment, so 3110 sub 4 says the claim accrues when the charge is incurred. So the patient can sue before benefits are overdue. The patient you can assign the cause of action, not the benefits. So there's a distinction between assigning the patient's rights versus the rights to an account receivable because those benefits aren't payable yet. A better way to say it, the patient's claim accrues at the time the charge is incurred, and that claim, that cause of action, can be transferred immediately regardless of whether the benefits are payable. Because it's just transferring a cause of action, not the benefits. So when it's a provider in turn assigning to a factoring company, they're not assigning benefits. They're assigning the right to money for that account. So it's an assignment again of a beneficial interest.
Then
Go
is
ahead.
that governed by the no fault statute?
Yes, they are. Yes, it's all governed by the no fault statute. I agree. What I'm saying is the patient's right to assign a cause of action is different than the provider assigning away a right to benefits.
Mm-hmm.
But again, I can understand that. I'm probably not explaining this very well. It's a very good question. It's also why I don't make this argument. There is an answer to it, but it muddies the water so much, it's not worth it. Right. So again, and this is probably, Wayne's probably back there, records or, scratching his head. Again, this is one of the arguments that he probably would suggest that shouldn't be made. And I would agree with that on this particular issue. It's probably right, but it's not worth the ramifications if we can't express it correctly.
Exactly. Yeah. All right. Thanks.
Awesome. All right. Thank you so much, Matt. A wealth of knowledge there. Wow.